Item number 1 and 2.
Make please, your lordship.
This is ready to go on?
Yes, yes. On the last occasion,
Yes.
uh,
Let us make a first call. We will come back immediately.
yes.
Pass over.
Item number 3.
Wait, please, Lordship. Lordship, if we have filed our affidavit, Lordship, in reply to the latest report.
What is this matter about?
Lordship, this is the PIL pertaining to the traffic.
Please louder.
PIL pertaining to the traffic congestion in Shillong.
Let it be here.
Lordship, if I may submit, Lordship, this.
Have you filed any affidavit?
Lordship, we have already filed our affidavit, Lordship. We have served the state also, Lordship.
Where is the affidavit?
Lordship, affidavit is on board, Lordship. If, Lordship, if I may pray, Lordship, this matter can come up next week, Lordship, as my learned senior who's leading the matter, Lordship, is on sanction leave.
Yes, yes. Item number 1 is the affidavit. What do you say?
My lord, we may be allowed to seek instructions, my lord. Other than that, my lord, we'll kindly see them. My lord, not as such per se, my lord, given a detailed affidavit concerning the last report that was filed before this honorable court, my lord. My lord, they have only given reference to all the, my lord, summed up all the reports, my lord, which is listed in the table, my lord, 1 to 13. But per se, my lord, concerning the last report which is filed before this honorable court, Lord, as such, my lord, that they have not given any
You
response.
see, we are adjourning this matter for 3 weeks.
My lord,
We are taking note of the allegations made here.
my lord,
And we are directing you to file another report to show that not only a plan is formulated by you, but action has been taken in terms of the plan.
my lord.
It may not be concluded, but it should be initiated.
Yes, my lord. In fact, my lord, in the previous report also, he had given some statements regarding actions taken, my lord. Nevertheless, my lord, we'll do that.
Action is paper action,
Yes, no,
demarcation, registration, etc. But actual relocation,
my lord. So we'll do that, my lord.
My lord, as far as this relocation of these hawkers, my lord, there is nothing has been done as far as Limekra area is.
we have read your affidavit.
Yes.
Because, my lord, we have decided to move phase-wise, my lord. At a time, it will be difficult, my lord, in my respectful submission. Unless, nevertheless, my lord, next date we'll file a report.
Marked in pencil, paragraph 1 and 2 of the order dated 21st May. By our order dated 21st May 2025, we permitted the petitioner to file an affidavit dealing with the report filed by the state government. An affidavit affirmed on 2nd June 2025 has been filed by the petitioner. Full stop. There is paragraph, there is some substance in the statements made in that affidavit. It appears that although the government has taken steps for registration of authorized vendors, identification and allocation of vending zones, with a plan for erection of several hundred stalls and adopted the policy to relocate these vendors to those vending zones, the scheme christened Meghalaya State Vendors Protection of Livelihood and Regulation of Street Vending Scheme 2023 has not been implemented. Full stop. As a result, the problem of illegal occupation of road space and footpath and congestion continues. Special danger is caused to school-going students who are unable to use the footpath, are compelled to walk on the road, endangering themselves to traffic accidents. Paragraph. Learned advocate appearing for the state assures the court that the government is keen to implement the above policy and scheme expeditiously. Paragraph. In view of such submissions made, we are prepared to give his client a chance to carry out our order and the commitments expressed in its report. Paragraph. We adjourn this public interest litigation till 3rd July. By 1st July, the respondent state shall file an affidavit showing action taken in terms of our order and the above scheme, and circulate a copy thereof to the advocate on record for the petitioner.
My Lord, we may be allowed to respond to the affidavit as well, my Lord.
In the report you do so?
My Lord.
Number 4.
My Lord, 3
In
and
the
4
said
are
report.
same matters, my Lord.
In the said report, the state might also deal with the statements made in the affidavit filed by the petitioner today.
My Lord. Obliged, my Lord.
3, 4 same.
Yes, my Lord. Common order.
Common order.
Yes.
See, there are two matters, similar order. 4 is different.
My lord, as per the last order, my lord, 8/5/2025, my lord. My lord has given direction that the amicus curiae, my lord, to hold meeting with the members of the Christian community, my lord. My lord, the meeting has already been held with members of the Christian community, my lord, along with the Deputy Commissioner, my lord. We have received some inputs from them, my lord. We'll file a report. My lord, may kindly give us some time so that we can file it.
Lordship, the direction was for the state also to file a report. Even we have received some instruction, Lordship. Kindly just give us some time. We also will file a report. No, 3 weeks. No, 6. Super.
Please take down. Initially, the scope of this public interest litigation was confined to facilitating the cremation of persons belonging to the Khasi and Jaintia communities on one hand, and those embracing the Hindu religion on the other hand, throughout the state of Meghalaya. The main issue was regarding death of crematoria and the lack of willingness of the two communities to share a particular crematorium. Paragraph. By our order dated 8th April 2025, we had appointed an amicus curiae and directed him to hold meetings with the district magistrates and representatives of the two communities to arrive at some kind of a settlement for sharing a crematorium. Full stop. We had also observed that the government was in the process of constructing new crematoria in various regions of the state. By our order dated 8th May 2025, we noted that some conciliation had been reached between the two communities as a result of our order and action taken by the said committee. Paragraph. But a new problem was taken note of by the court. Also, there was similar discord between various denominations of the Christian faith. To share asymmetry. By the said order, we enlarge the scope of the public interest litigation to include the Christian community also. Next, we directed the three district councils, namely Khasi Hills Autonomous District Council, Jaintia Hills Autonomous District Council and Garo Hills Autonomous District Council, to be made party respondents. We directed the amicus curiae to hold similar meetings with the district magistrates and members of the community as they had held with regard to the problem faced by the other communities noted above. Paragraph. Both the amicus curiae and both the learned additional advocate general and Mr. Khan and the amicus curiae submit before us that some progress has been made in this direction and want time to file a report. Full stop. We grant the committee time till the next hearing of this public interest litigation to hold meetings with the various denominations of the Christian community and arrive at some kind of a solution to solve the problem of burying the dead in cemeteries. We adjourn this public interest litigation till 3rd July to enable the state and the committee to file separate reports by 1st July 2023, serving copies thereof on the advocate on record for the petitioner. District councils have been served. The Registrar General must have shown it. Any communication from the Registrar General's office? Check up.
What happened with the notice? They haven't appeared, no? Seriously, they are very important. How do you...
Was this order sent to the Registrar General? How this order was not forwarded to the Registrar General and appears not to have been sent to the three councils. The courtmaster attached to this court is directed to immediately send the relevant orders to the Registrar General for service on the councils. Then at the end you write, the concerned district councils will cooperate with the state and the committee for implementation of this order. Today only you said.
Number 5.
What you do,
This is the matter concerning tree fellings. Directions were issued by the Honorable Court on 9/4/2025, and the state was directed to file a report.
Made pieces, Your Lordship. Lordship, I'm praying for some more time, Your Lordship, to file the report, Your Lordship. We need some more time, Your Lordship.
what is the subject matter, Mr. Paul?
Well, this pertains to felling of trees in and around Shillong. Certain directions have been issued. My lords had directed formation of a committee, and my lords, all the applications were to then processed by the committee and a report to be filed before the Honorable Court.
How much time you will take to file?
Lordship kindly allow us a 6-week time, Your Lordship.
No.
6 week, Your Lordship.
Well, this order was passed on
9th of
9/4, Your Lordship.
April.
Lordship,
So you have done nothing, and the trees are being felled.
Lordship,
We are keeping some action. You have to show.
Lordship,
We are keeping it after 1 week. Some action you have to take. Then we will give you time to take further action.
then let it be 2 weeks, Your Lordship. 2 weeks time, then we'll inform Your Lordship accordingly after 2 weeks, Your Lordship.
Please take down. This public interest litigation initially. Oh, 1 minute. Paragraph 1, 2. One and 2 of the order dated 9th April 2025. Then by our order dated 9th April 2025, we extended the scope of this writ to cover cause of action in all districts in the state. By our said order dated 9th April, we had directed the state to file an affidavit with regard to the action taken in terms of our said order to stop illegal felling of trees. In terms of our said order to stop illegal felling of trees. Paragraph. It appears that no action has been taken till now, since no report is filed by the state. Learned Additional Advocate General Mr. N.D. Chulai prays for time to file a report. Accordingly, we adjourn this public interest litigation till June, to 24th June, to enable the state to file a report, full stop. At least initiation of action and some positive action, no, at least initiation of and some positive action in that direction must be shown in the report. A copy of the report is to be circulated to the advocate of record for the petitioner by 23rd June.
Highly open.
Number 6.
May it please your Lordship.
Yes,
Lordship, earlier this Honorable Court directed us to approach before the Family Court, Lordship.
yes,
Lordship, accordingly, we have submitted a petition 155/2025
yes,
under Section 43 of Guardianship and Wards Act, Lordship, to enforce the earlier order of the Family Court to enable the petitioner to avail the
visitation right of the child.
Visitation right. My lord, the case is little bit different, lordship. This is not a case that visitation right is simply denied, but the case is that, lordship, the child is missing, my lord.
The child is missing, the court has enough power to salvage the child.
Lordship, the family court has returned the petition, lordship, without passing any order, lordship.
Where is the order?
Lordship, the petition has been returned, lordship. No order has been passed. In the petition, lordship, the court has put the seal and signature regarding registration of the case, lordship. But after keeping the petition for a few days, lordship, it has been returned, lordship.
How it has been returned? What are you saying?
Lordship, the original petition, lordship, I bought, lordship. Here the seal and signature of the family court is there.
It is returned if it is filed in the wrong court.
Lordship, it is
Order
filed in the
7,
family
Rule
court,
10.
my lord.
Don't make these submissions before the court.
My lord.
Order 7, Rule 10, it is returned to present before the correct court.
Lordship,
the right
this,
court.
my lord, this honorable court directed us to file the petition before the family court Dhuburi in the state of Assam. Lordship, we have submitted the petition in the family court Dhuburi in the state of Assam, lordship.
Then
The family court which earlier passed the visitation right order, lordship. Then also, lordship, the petition has been returned. Lordship,
where is the order? Returning the petition?
the returning the petition, there is no order. The petition is returned, my lord.
How? If the department returns, they will also put a seal.
After putting,
Is it something informal or what?
no, lordship, formal petition, lordship, formal petition I have submitted and
that I am paying 10 rupees to buy a kilo of potatoes, you take your money back. Is it like that in courts nowadays?
lordship, I have
Don't make you come back properly instructed.
My lord, the petition I have bought, wherein the seal of the court is also there, my lord.
With what notice the remark?
My lord, nothing has been marked, my lord. Nothing, no order has been passed, my lord. That is why, lordship, I am.
You don't know the procedure of filing, and you will come and disturb this court.
My lord, earlier also I have filed the petition, lordship. In that case, the court entertained the petition and passed order, lordship. Lordship, I have filed in proper procedure, lordship. Lordship, myself, I was present in the court, lordship. My signature is also there in the petition, my lord. My lord, it was filed under section 43 of Guardianship and Wards Act, my lord.
Show the petition.
My lord, my lord. In page number 6, affidavit, seal of the court is there, and in the alternate side of page number 6, seal of the family court is also there. Page number 6, my lord.
How have you got hold of this? You went to file it yourself.
My lord,
You went to file it yourself.
my lord, my petitioner went.
Petitioner went.
Petitioner went, and petitioner is also present today, lordship here. My lord, some other vital developments were also there here in this case, my lord.
Who was his advocate in that court?
I was the advocate, lordship. My signature is also there in the alternate side of page
You
number
did
6.
not go.
I went there, my lord. I myself went there.
Then you are saying your client went?
My client is sitting outside the court, my lord.
Yes.
He was here. He was there also.
You have only stamped it and affirmed it. Nothing else. This seal is of the stamp reporter. You are trying to hoodwink the court, or you don't know anything?
My lord, as per
There
order,
is a filing procedure.
my lord, I have filed in the filing section of the court, my lord.
Don't expose yourself to trouble.
My
If
lord.
you are referred to the bar council, it will
My
be serious consequences will happen.
My lord,
You are trying to hoodwink the court.
I apologize, my lord.
Yes, I'm tendering apology. You know what you are tendering. It is just stamped. That's all. And you have taken no steps further.
My lord, it was submitted 155.
And you have taken back the petition, and you think you'll hoodwink the court. The court returned the petition.
My
Like the
lord,
court returns the petition like this.
my lord, this is not the case. Happened only with me for this first time, my lord. Other petitions were also returned in this way.
Very good.
My lord, some vital development, my lord, took place. Lordship, we have filed an RTI application before the state of Meghalaya, my lord, regarding obtaining
This application is adjourned. Till 10 July 2025 to enable the petitioner to take appropriate steps in the matter as directed in the earlier order. Give it back to him.
obligation.
You are very junior, the court is sparing you. What you were trying to do is most condemnable. You have gone and just stamped the petition and saying the court has returned it. The court only returns under Order 7, Rule 10, where it is in the wrong court. And that too under proper seal and signature. Don't do these things.
Obligation, lordship.
You have not even tried to file it. Yes, next matter, please.
Obligation, lordship.
Number 7.
Hearing matter.
This matter relates to the grant of centralized contributory provident fund to the teachers of deficient colleges in
Ready for
Meghalaya.
hearing.
My lord,
No,
EG was appearing. I do not know whether.
Lordship, hearing may not be required, Lordship, because we had sought for time in the last date.
Settlement.
Settlement and Lordship, there's some positive development.
So when should we keep it?
Lordship, at least after a month.
Sorry?
Kindly grant us a month's time because we by
What has
most
happened is all other procedures have been done. They need to notify the centralized provident fund scheme.
Lordship is.
If they notify the scheme in the gazette as required by the law itself, most of our grievances would be closed. But that notification is not coming from November 2024. The time has been going on that either we are coming to a conclusion or they are requiring some more time. So 2024 November till June 2025, one notification on the scheme is not coming up. Otherwise, we are ready to cooperate. We have given them the draft. They had given us a draft. We made the corrections.
Can you please intervene?
Lordship,
We are keeping it after 2 weeks or
Lordship, kindly grant us a month's time. Why? For the simple reason, Lordship, I'll just apprise this court. This
all right, you take 1 month, but let it not be an empty exercise.
Lordship, absolutely. This is the draft proposal where we are inviting applications, Lordship, from the prospective tenders as to how to go about in managing the fund.
All right.
So that is in the stage of
By
draft.
consent of learned counsel for the parties, this writ petition is adjourned till July 2025. So that the issues involved may be resolved at the intervention of the respondent.
Much obliged.
I'm deeply obliged.
Number 8.
How many matters you have put? Hearing matters?
Lordship, my other side is coming with forward for fixed the matter on 17th proposal.
Yes, Your Lordship, we are praying for time, Your Lordship.
17th is all right for you? 17th?
Yes.
I actually, yesterday I told the Malayalam friend they are on 27th, Lordship. Now today they are coming with I wanted to accommodation.
No, we will go by your convenience. You are very senior. 27th?
No, mine is on 27th.
All right. List this appeal for hearing on 27 June. Next.
Number 9. Much obliged.
Come.
May it please your lordships.
Yes.
This matter may kindly be taken up on the 16th of June, my lord. Senior counsel is unavailable today.
What do you say? All right. By consent of learned counsel for the parties, this appeal is adjourned till 16 June.
Another writ petition tagged with this. 57 up to 24.
All are tagged together, all the trees.
Is it appearing in the list?
It's appearing. 3 readables have been tagged together.
What are there?
Which one is this? Item number?
Item number 9.
All right. Put all the matters.
Yes, very.
Number 10.
Much obliged.
Yes,
My lord. My lord, this appeal I'm appearing for the respondent. My friend is appearing for the appellant, my lord.
that is number 1.
My lord, item number 10 on lordship's
Number
list.
1 is passed over. Number 1 is not passed over. They are not appearing in number 1. Yes.
My lord, my friend is appearing for the appellant.
Yes. What is the issue involved here?
My lord, learned single judge had passed an order in my favor, merely asking the respondent corporation to consider my case for temporary appointment. Similar, on the same lines as 20 other persons, similarly situated persons have been appointed. That is all, merely to consider my case. So instead of considering my case, the corporation has come on appeal before my lord.
This is ready for hearing.
I'm ready. Otherwise,
You are ready? Unmute yourself. Please unmute yourself. Is there any problem with us? You are ready to go on with the matter?
Lordship, if I can.
He's praying for accommodation, Your Lordship.
In the morning, my lord, my friend had contacted me saying that he's not in a position today.
When do you want it?
After 10 days, Lordship.
All right. 24th. By consent of learned counsel for the parties, list this appeal for hearing on 24th. Yes, call the last matter.
All right.
Number 11.
Item number 11.
Yes.
My lord, in this matter, the only question which arises for determination, my lord, whether right, title and interest can be decided in writ proceeding, where, my lord, special provision under CM.
You are ready to go on with the matter?
Your Lordship, I seek for some accommodation, Your Lordship, as Mr.
Why?
Humphrey is on leave.
Sorry?
The arguing counsel for respondents 1 to 3 is on leave, Your Lordship.
Nobody informed me, my lord. I have come from Guwahati for this matter. They should have informed me yesterday.
For respondent number 3?
1 to 3.
Sorry?
1, 2 and 3.
You are assisting him?
Yes, Lordship. I seek some accommodation, Lordship. In this
No, accommodation he has come from Guwahati. You can stay for the night?
My lord, if I will stay, my lord, if the matter is taken up tomorrow, I will stay.
Yes, you get ready and do the matter.
Your Lordship, the arguing counsel is on leave, Your Lordship.
So what?
I pray for some accommodation.
He will go on leave and he will be put into inconvenience. You have not even informed him. 3.5, 4 hours he will come and again go back. You come tomorrow. Or yes, you wait. If the other matter which is passed over is over, we will ask you to start the matter at least today. Pass over.
Yes, second call, item number 1 and 2.
Please, Your Lordship. My Lord, on the last occasion, my Lord, I was taking your Lordships through the affidavit filed by the respondent PGCL, the appeal. And in terms of this affidavit, my Lord, they want to justify that in fact there was technical evaluation of the bids. But if I am permitted, my Lord, I can again take your Lordship to the relevant pages, my Lord. In my
we have taken note. I think we wanted a report from the government as to the quantity of work done by them.
That has not come. That has not come.
I think we.
Of course, I am yet to conclude my submissions.
No, that is all right. That is very important.
Yes. But if your lordship considers it from this point, that we are basically on the illegality of the exercise. Now, if your lordship holds, as the honorable single judge has held, that there is an illegality in the exercise, then, my lord, the question will still be whether, in view of the illegality, these aspects of the matter, as to whether the constructions have been done.
You see, there are two things. We have not discussed the matter with each other. We have to discuss the matter. These are just prima facie observations by me. One consequence will follow if nothing has been done. No money has been spent. No money has been tendered by the government to the contractor. It is at the time of acceptance of the tender. Suppose, let us assume the consequences, the whole tender is cancelled because nobody will suffer any prejudice and a bidding process will start. Financial.
Yes.
Second is, if with the passage of time, they have constructed, say, 40%, 30%, expended so much, RA bill, etc., submitted to the government, received so much. So whatever may have been the irregularity, it cannot be illegality, irregularity in the award of contract. And suppose we find that you should have been given a chance to participate in a bid, auction kind of a thing.
Yes.
3 rupees, 4 rupees, 5 rupees. The court can say, all right, you go ahead with the contract, but we will compensate you in damages.
My lord, that suggestion, your lord.
All right.
Yes.
And the third option, all these options are open, that there were only 5 bidders, 4 genuinely opted out, there was no cartel, nothing. There is no evidence before the judge to come to a finding that there is a cartel. Technical bid, for some reason, the court will not go into those kind of technical matters, whether the technical evaluation was correctly made or not. The contract is upheld and the writ is dismissed. Now, all these three alternatives are open before us. So it is very important how much work has been done?
Now, my lord, here also, my lord, our case has been that, in fact, there was no technical evaluation at all. That is one aspect of the matter. Second aspect of the matter is that even before the contract could be awarded, my lord, I mean, this contract could commence, my lord, we approached the court and this honorable court passed an order saying that it will be subject to outcome of the writ proceedings and it will be at their risk and cost. Now, in that scenario, my lord, whether the subsequent actions done by them, subsequent work conducted by, completed or executed by them will be a relevant consideration. My respectful submission will be, my lord, knowing fully well they remained absent from the proceeding of the honorable court, they did not.
But Mr. Dotto, in case of technical evaluation, unless there is kind of gross abuse of the process.
Well, that is our case.
Unless it is gross abuse, how can the court go into the technical evaluation?
My lord, that is
their headache.
My lord, that is our case, that it was a gross abuse inasmuch as, my lord, there was no technical evaluation done at all, and Honorable Single Judge has returned that finding, that there was no technical evaluation. Honorable Single Judge has returned that finding, and that is based on the assessment of the records which were produced at the hearing.
Like if a car driver is allowed to fly a plane, that would be a gross abuse of a technical evaluation.
Exactly so. Exactly so. Here is a case, my lord.
That, how can the court evaluate what?
Now, my lord, the Honorable Single Judge did not went into the aspect of evaluating for the court as to whether the evaluation was proper or not.
All right.
Honorable.
Mr. Pandey, have you done this exercise?
My lord, yes, that technical evaluation was done and that was shown to your lordship. And,
No. This the quantity of work done.
Yes, my lord, that is also done. My friend there is having a copy of the status report. My lords, as far as the earthwork is concerned, the earthwork is completed almost to the extent of 95%. And my lords, in terms of amount of work done, the amount is about 23 lakhs is the amount of work done by the contractor.
Well, there was also an order from your lordship that this should be also shared with us. We have not been posted with these papers.
My friend can provide a copy.
Mr. Pandey, please enclose this in a one-page affidavit and give him a
Yes,
copy.
my lords, I will do that. Yes, my lords, I will do that.
Please take down. Further to our order dated 19th May 2025. The Executive Engineer Shillong, Civil Division Roman 2, MEPGCL Shillong. Has filed a report dated 4th June 2025 containing progress of the work, comma, photographs, and a statement of payment made. Of the work done by the respondent number 2, photographs and payment made to him. Paragraph, we feel that the nature of the report is such that it should be in the form of an affidavit. Vouching for the correctness of the statements made in the report. Full stop. The report may form the annexure to the affidavit. We direct the state to file this affidavit by 18 June, serving a copy thereof to all the parties. Full stop. Any party may file an exception to this report in the form of an affidavit by 24th June, also serving copies thereof on the other parties. List this appeal for further consideration on 25th June.
Now, can it be on 26th?
Yes, yes.
26th.
26th June.
Obliged.
Which of it?
At the top. And marked as parted. You mark it parted. So that I will know that this matter is applicable. In the list you mark as parted. Next, call the passed over matter. You give the list.
Second call, item 11.
Yes, please.
My lord, in the present case, my lord, writ petitioner, they are respondent in the present matter. They have challenged mutation. It was done in my favor, your lordship, saying that opportunity of being heard where it was not given to them. My lord, against the order, matter relating to right, title and interest, there is a specific provision under Khasi CMC Administration of Justice Order 1950, my lord, where CM court has been created, and my lord, to try suit relating to my lord property, civil court power has been vested in CM court, your lordship, and the procedure of Code of Civil Procedure is also applicable as held by this honorable court. First, I am placing, my lord, the relevant provision, my lord. Because here, my lord, disputed question of facts are there, my lord. It is required to be, my lord, evidences are required to be adduced. Simply, my lord, by way of writ petition.
No, not simply by writ petition. All this cannot oust the writ jurisdiction of the court. But then, in view of these provisions, the writ court might refrain from exercising its power.
Why I am saying
because
so?
There is an alternative remedy.
My lord. Why I am saying so, my lord? What the learned single judge has done, my lord, on the basis of the statement given by other side, your lordship, matter was remanded back. In that matter, my lord, my right, title and interest are vested, my lord. That cannot be decided, my lord, by writ court because of the, my lord, there are disputed question of facts. There is an FIR, my lord, against them, my lord. My lord, kindly see clause 19.
No, let us see the order, impugned order.
Impugned order, my lord. Your lordship may kindly. Where is my ID? page 197, my lord. Relevant page 198. Oh, paper book, in paper book it is different, my lord. In paper book 218. Give me paper book. $218. Starts from 219. And submissions were recorded, my lord, that they were not heard. In fact, this is incorrect. That I will show, my lord.
When was the patta granted?
My lord, page on 11th March 2024, page 210.
11th March?
11th March 2024.
How can it be?
My lord, what,
Patta 233 of 2022.
22, it was granted. This is the order, my lord. 11th March, it is written that this matter is disposed of at this is by itself, setting aside the order dated 11th March 2024. In the order itself, your lordship will see, para 4. Patta number is 223 is the patta number, my lord.
Of 2022. First paragraph of the judgment.
My lord, my lord. It is in respect of earlier patta, I think. My lord, it is there, my lord. Page 192.
Were you represented, your client?
My lord?
Your client was represented?
In
Before
that,
the
no, my
report?
lord. It was granted in favor of, my lord, respondents. So we approached the...
You were a respondent in the writ?
Yes,
my
the
lord.
respondent.
Were you represented
My
before?
lord, in fact, in that matter, learned senior counsel was engaged, and by that time he reached...
Yes or no, whether he was engaged or...
She was there, his junior was there, your lordship, but...
What is the name?
My lord...
On that particular day, Ms.
Gurung.
K. Gurung.
Gurung.
Yes, your lord.
She was
She
there.
appeared. She was there.
She did not oppose?
She
But
did not...
she uttered a single word, my lord.
She did not make any statement when I made a statement on behalf of respondent number 1 at that during the writ petition.
It's a valuable right. The government is saying, okay, we will consider them, but they are the beneficiaries. In 1 second, it is gone. They should be remanded back.
Your lordship,
First,
if
consider the maintainability of the rule and whether, and if yes, whether it was granted without hearing into the merits and then pass it on.
your lordship, if I may make a submission.
No, why you will make your submission? They are the beneficiaries of the order, patta.
Yes, Your Lordship.
And respondent number 1 is the adjudicator,
Yes,
the
Your
land authority.
Yes. I am respondent number 1
Yes,
in the writ petition.
you are saying to the court, yes, I will adjudicate again. But by that, you are depriving him of a very valuable right.
Yes, Your Lordship.
So we will remand the matter to the writ court.
Yes.
The writ court will consider its jurisdiction first,
Yes.
as pointed out by learned counsel. And second, whether on merits this order is liable to be set aside.
Yes, Your Lordship. Yeah, no problem. That's why I want to make a submission that as per the prayer that let this matter be remanded back to a single judge. We have no objection to that.
And there you have no objection to the patta being set aside.
No, Your Lordship, it's not that. Let the matter be heard.
So
be
many
heard.
things are there. FIR is there. What
Yes, we will file the detailed affidavit to all the allegation made by the petitioner.
Yes. There is substance in this appeal. Paragraph. We do not hesitate to observe that some confusion was created before the learned single judge. Full stop. Paragraph. The question in the writ related to legality of grant of patta number 233 of 2022.
233. 233 is the old one.
Old one. This is,
Not
I think, wrong.
233, Your Lordship.
It should have been, my lord. It is wrongly written, my lord. I think. It should be, my lord, page 189, my lord. And in the of writ appeal, your lordship, 210 in the paper book.
I think it's patta number 113 of 2024. Patta number 113 of 2024, Your Lordship.
Okay, 113 of 2024.
As per this. No, this is the order.
It was in favor of the appellant herein. She was respondent number 2 in the writ. The first respondent was the local authority, the Salem Hima Mylium and Darbar Mylium CMship. Mokhar Main Road, Shillong. See page 218 of the paper book. Paragraph. It appears that the respondent number 1 consented to the patta being adjudged void and being set aside. Paragraph. On that basis, the learned single judge by the impugned Judgment and order dated 5th December 2024. Granted the said relief. Paragraph. It appears that the learned advocate engaged by the appellant kept quiet, neither supporting nor opposing the order proposed to be passed. Paragraph. The person affected by this order is the appellant. The case of the appellant was not represented at all before the learned single judge. Paragraph. Today, learned counsel for the appellant makes the following submission. Colon, Roman 1, the writ application was not maintainable inasmuch as there was the existence of a complete alternative remedy in the Khasi Siamships bracket administration of justice bracket closed order 1950. Mr. Lam. This court ought not to have entertained the writ application. Paragraph. Secondly, the assertion that the respondent numbers 1 to 3 were not heard is completely erroneous. There was no breach of the principles of natural justice. This submission was made in the alternative in case the court proposed to exercise its writ jurisdiction, rejecting the first contention. Paragraph. What is most material is a valuable right of the appellant has been extinguished without considering his case. Paragraph, in that view of the matter, we set aside the impugned judgment and order dated 5th December 2024. We direct that the writ petition WP bracket C number 337 of 2024 be heard afresh, considering the point of maintainability and jurisdiction of the court first, and thereafter the merits of the matter, if required. As early as the business of the learned single judge permits. The appeal is allowed.
Deeply obliged, my lord. I bow down, my
But the writ petitioner is not appearing today.
writ petitioner.
Yes.
I'm appearing on.
He is appearing.
Writ petition for respondents 1, 2, and 3. Your Lordship.
Writ petitioner.
Writ petitioner in the writ petition.
And you are for?
Respondent number 1 in the writ petition.
Counsel.
Yes, counsel.
You are the counsel.
Yes, for the respondent number 1.
All right. All the parties are
all parties.
You get it heard out afresh. Good.
Deeply obliged.
Please record all names.